You know, counsel makes it sound like I got Special Master Hale to order to be taken from the hospital bed. That is not what happened here. And fourth, and I think this is the key point, he goes on and on about how his own witnesses, the general manager, his testimony is poppycock was his word. Nonsensical was his word.
Thank you, sir. So I'm going to address the actual motion first. And the court can deny the motion on two grounds. But the most important one is procedural. They did not, in fact, bring any claim for breach of implied warranty under 104-2315. Now, you can always, come to court and file a motion for leave to amend, and it's generally freely given. They could have done that. In fact, they did it multiple times in this case. And most recently, they did it in February of this year. And they came on this particular case and asked to amend the pleadings for a second time, and chose specifically not to include a breach of implied warranty claim as against Milwaukee and Hanna for that matter. And the reason I say it's intentional is because at the same time they filed the motion in this case, they filed a motion in 10 other cases to amend their pleadings. But you know what they did in those other 10 cases, Your Honor, that they didn't do in this one? They added an 8th cause of action. What is that 8th cause of action? It's breach of implied warranty. So that, the question I didn't hear answered, that Your Honor is probably wondering about is, why didn't you just amend it in this case? Give them notice that this was a claim you were going to pursue in this particular case. Give them an opportunity to go question the plaintiff opponents about this issue. Maybe have their expert prepare a response for this particular issue. I don't know why they did that. My suspicion is they knew by adding a new cause of action, which is what it is, they might have had to kick this trial date or discovery dates. I don't know. They can explain that. I won't get up here and guess at why they didn't do it. But the fact of the matter is, they're up here asking for summary judgment on a cause of action they never pled, and they didn't plead it intentionally. And for that reason alone, the court needs to deny this summary judgment motion. I don't care how you want to limit it. You're asking for a breach of implied warranty claim, and a finding as a part of that claim that you did not plead, and you did it intentionally. And although you can file a motion, to this date, they've still not filed a motion for leave to amend to add this cause of action as against my client. There is a cause of action against Real Water on the breach of implied warranty, but it's for the product of Real Water, not an ORC meter. So there are no allegations in that complaint. The 3 cases that they cite in their reply all talk about when there's extra notice, and extra notice that they had. And one example, I think, is the Lipton or Lipton case, where they say, well, he didn't, the officer who felt he was wrongly fired didn't put a claim in there that he should have put in claim. But if you go back and look at his ECC complaint, he did put in the language for that, so that there's actual notice of it. And that's fair notice. Here, we have the opposite. We're being told in mid-February, when they file these motions for leave, that you're not going to be dealing with that issue in this case. We may be dealing with it in the other cases, but in this case, they specifically chose not to include it. So the discovery that was had at that point, we were all, at least from my office, I was operating under the assumption that we're not going to be dealing with that claim. They're just not going to go forward with that claim. And then they file a summary judgment motion on it, on a cause of action they have not included. Now, if we want to talk about, substantively, if there's issues of fact here that would prevent you from granting the summary judgment motion, we've included on the last page of our opposition, page 12, is the deposition testimony of Jason Brown, where he says he had no idea they're making alkaline water. Now, he does, in his deposition, talk about he's aware of Kangen water. And Mr. Kemp flippantly says, Kangen water and Real Water, they're the same thing. They are not the same thing. They're not even close. Kangen water is this expensive little machine that you buy and you put it on your kitchen counter and you plug it into your faucet. You know what it doesn't do? It doesn't add hydrazine to the product. It doesn't include Russian titanium tubes. It doesn't include Blaine Jones going back in the back room, locking himself in and mixing up the secret sauce and putting it into the product. They are not the same product. Kangen is not real water. It's not even close. The only thing you can say that they share similarity is maybe that they have alkaline water. But they're completely different products. And he's unaware of what, he's certainly unaware of what real water does. He doesn't even know that they're, if you even thought they were Kangen water people, he doesn't know that. He has no clue what they're doing, and he certainly has no clue that they're putting hydrazine in bottled water and selling it, or that they're mixing in all these products with it. It has no clue about that. And so at the time of contact of sale, which is what's relevant under 104-2315, is at the time of contact of sale. He has no clue, and that's what the deposition testimony we provided you on page 12 of the brief shows. And the knowledge that he does have about just generally the product for Kangen users, yes, he knows Kangen users are using it. I guess I should touch on this fact now. I think we're going to do it a little later, but I think Your Honor is well aware of Mr. Brown's medical conditions. The effort, I'll just say that politely, that plaintiff's counsel made to try and get him to a deposition. He was in a coma like mid-October due to COVID. He has a very compromised immune system due to, I believe it was a kidney transplant.
You can push that down if you want to, sir.
Oh, sure.
Yeah, there you go.
So that's why he really did get sick, and I tried a case in front of Your Honor during COVID, and we knew how serious it was, and he was one of those people where COVID really did affect him, almost lost his life. So he was put into a coma. He had weeks of rehab. He tried to return to work mid-November, made it a couple of hours, had to go home, got sick again. Was ordered by his doctors to stay home for, I believe, about another month and a half. And the day he was allowed to come back to work was, I believe, February 1st, maybe the end of January 31st, something like that. And they wanted his depo 2 days later, and they had filed, motions for sanctions, stuff in front of Special Master Floyd, just unending, because, apparently it's only when their clients are sick that it matters. So we've responded to that. That's a separate motion. We'll get to that when we get to it. But I only bring that up for when he talks about, 1/3 of the customers, and he knows about Kangen, and then he said that it takes a day to get a reading if you don't oxidize a probe to get a negative reading. It's all poppycock, nonsense. You're never going to hear an expert in this case say that. I don't know if he didn't understand the question, and certainly they can ask him that again at trial, and he can explain it, but I guarantee you, he didn't either hear it or understand it, or when I was there that day, I had to sit in a different room from him because I didn't want to get him sick. But he was shaking like this during his death. The guy wasn't helping. He's in rehab to this day. So he's not my PMK, notwithstanding what they say. He's not my PMK for this case. He's a nice guy, but he doesn't have a lot of knowledge on the topics that he was asked about that day. Why? Because he wasn't noticed as a PMK deponent. So he didn't prepare on the topics. If they wanted to ask about Kangen water or sales or any of this other stuff, they could have provided him with those topics. We could have prepared him if he was going to be the PMK, but he wouldn't have been. And he's not going to be, and they have a notice of deposition out for a PMK deponent. It's not going to be Jason Brown. He doesn't speak for the company. He is a manager. You're welcome to, during trial, call him as a witness. And if you don't like his testimony or changes, you're welcome to impeach him, but you're not going to pre-admit it. He's not a party opponent. And again, that's another motion we're getting into, but it was addressed in this motion for some reason, so I'm trying to go through it. The other thing is reliance. So it's a two-part test. You gotta have knowledge at the time of the contract of sale, but there also has to be reliance by the buyer. And they've been buying these port meters since 2011, Your Honor. You know how they decided to buy these meters? It wasn't anything we said. They didn't call us up and ask us for advice. They went to John Marlowe, the inventor of the real water product, the guy who formed chemistry. Okay? They went to him and he said, well, this is what I use and it works great. That's why they bought these meters for all these 10 years. This is nothing that we said, nothing that we did. We had no knowledge of what it was they were making. We certainly didn't know they were putting hydrazine in there. And to come to court and say that somehow we contributed to these injuries because our meter took a reading of 130. And I would actually argue that it's probably a guess by Mr. Higgins what it was. But we'll ask him if we get a chance to talk to him at trial. But there's no evidence that the 130 reading was wrong. In fact, Mr. Jones says he continued to use the same meter all the way up until the company was shut down. Okay, and it took plenty of readings. And council's, I think there's a motion that says, you know, that it can't take that our org meter can't take a negative reading of more than minus 130. We just saw it on the video that it does. That's nonsense as well. You're never going to hear an expert in this case say it. And it certainly doesn't take a day to come up with a negative reading. In fact, the testimony is going to be from the experts in this case. The only experts that are going to talk about this product are our experts, because they don't have one that's going to say this. And you don't need to oxidize this probe at all. It makes about a difference of about 30, 40 seconds. And if you don't, then you're going to wait 30, 40 seconds longer. You're not going to wait a day for a reading. Would anybody really buy this? Would common people buy this? No, of course they wouldn't. Nobody's going to wait a day for the reading. You don't have to oxidize it at all, and it works fine. I've taken this, I bought one myself and stuck it in common water that they said was negative 600. Got a reading in about 45 seconds. And I didn't oxidize anything. And our experts are going to say the same thing. So all that's not true either. But I just want to make it clear, common water and real water are not the same thing. They're not even close. The Blaine Jones video we were shown where he was mixing it up, my understanding is that he's going to testify that that was for a sales presentation. I don't know if it was cut and edited. I don't know if that clock is correct. I don't know. We'll have to get to that. But that was done for salespeople. It's a trick to say, hey, look how it changes color. And, you know, you can take one of these old meters that we have and take it out and do this in front of customers and clients, Costco's or whoever in the world, and show them what it does. So that's not any of the plaintiffs saw that video. They didn't rely on that video. None of the plaintiffs, to my knowledge, have never even seen an org meter, don't know what an org meter is. They weren't given an org meter. They never touched the org meter. They were never in a room with the org meter. So, you know, when you get to the causation question you asked us earlier, that's going to come up, and I suppose we're going to have to brief that a little bit. This thing about, again, going back to the video, that he only soaked it. I said that you need to soak it for 5 minutes. Whether he said it or not, the reality is this thing sat in vinegar 23 and a half hours a day. So every time they weren't reading it, it was soaking in vinegar. So if you want to believe that, or if you want to get it expedited or more efficient, I think is how they ultimately, and by the way, the product he has another tip card in it that went in after 2017. He didn't show that to you. Doesn't say the word he says, it says efficient, faster. You get a faster reading. Not a much faster, but a slightly faster reading if you put it in vinegar. So this thing was soaking in vinegar, whether they intended for it to do it, whether they thought you only had to do it for 5 minutes. It did in fact soak in vinegar for almost the better part of the day, every day. So it was being oxidized, even if it was by accident. The Mike Bush email. So he just showed you the Mike Bush email where there's some correspondence between Mr. Brown and Mr. Bush, and then he showed you his deposition testimony where he says, yeah, I made a mistake, I shouldn't have told him that. What he didn't tell you, Your Honor, is 2 minutes after that email, and he wasn't given this email, we didn't know this email existed, but there's another email 2 minutes later. 2 minutes, it's a separate email from Brown to Bush at Real Water where he says, oh, yeah, don't use that link I gave you because apparently MA9025 was discontinued 2 years ago. So, but he didn't know that because he wasn't prepared on that issue. I don't even know if they ever even knew what MA9025 was. But he sends an email back saying, don't do that, put it in vinegar. So he did tell him. So Mike Bush saying, well, if they had told me, I would have done it. Well, they did tell you. And they were in fact doing it. And whether Mike Bush thinks he did it or did not put this probe in vinegar, he did. And there's an email 2 minutes later where he corrects that statement. So that link that they're saying that he sent it to, 2 minutes later he tells you, don't use that link, that one's wrong. And notwithstanding, when we did and I'll just throw this in, when we did do an inspection of the real water facilities, we found MA 9025. And when he was saying it was a mistake, he thought they had some MA 9025 there. Turns out they had the MA 9025 too, when they closed down. So they had both. But the vinegar's cheaper, it's easier, that's why they were telling customers to use it, and the MA 9025 was discontinued. I don't know if I got all the issues that were thrown out here. They weren't really part of this motion, but hopefully I've addressed some of the misstatements of facts or exaggerations. But the bottom line, with regard to this actual motion that was actually filed, they had a chance to plead implied warranty, they didn't do it. They intentionally didn't do it, because they did it in the other 10 on the same day. This one they didn't. And that's set forth on page 8 of our opposition, all the other cases that they did file for that particular claim. They chose not to do in this one, now they want to do some backdoor motion for summary judgment. You know, had they done it, the court probably would have granted it, we would have maybe had to continue discovery dates, but no, Your Honor, we probably wouldn't have, because you're pretty strict about that stuff. But, yeah, we could have deposed some of these final witnesses, we could have tried to get something put up by our expert, and the court probably would have allowed that. They chose not to. They want to wait till the day before, or a month before we're actually in trial and file this motion and try to backdoor that claim. I think it's a relatively minor issue, but procedurally, the court can't grant the motion. And substantively, there are issues of fact that prevent you from granting the motion. So no matter how minor they want to make this issue right now about saying we just want it for this limited purpose, you know, they on both procedurally and substantive issues, I don't believe the court is able to actually give them the relief they're asking for. Thank you.
Thanks, Rob. Mr. Kemp took away the other meeting, so I thought I would better bring one. Just so we've got it. I'm not sure he's saying that he's trying to keep it away deliberately, but the first thing I'd like to do, John, if you could just pull up the second amended complaint. Your Honor, Mr. Robbins went over this complaint. I want to go into it a little bit more detail. At the top, it was the date in which this was filed after the motion to amend was filed with the court. The date on that, I believe, is March, and again, I'm older than Mr. Parker, so I need to get closer. March 9th, 2023. At the seventh cause of action, which Mr. Kemp has alleged, we don't need to tell you we don't need to tell you. This is a notice pleading state. We just have to kind of suggest something. We have the seventh cause of action for this page. John, if you get to page. Here's the seventh cause of action. And paragraph 168 is interesting. It says this. It doesn't talk about fitness for a particular purpose. It says the MW500 ORP meter is an unreasonably dangerous product because consumers would not expect the ORP meter would not give accurate readings when used for negative ORP readings, or, here's the second thing that I have to defend, that the MW500 meter would not give accurate readings when used for negative ORP meters unless rigorously cleaned every 30 days. Now, I heard a lot of things that Mr. Kemp told us today. Well, who's this? Is this your guys'? But I didn't hear anything about cleaning. So the fitness for a particular purpose, the first part of 168 is there's not even accurate readings when used for negative. The second one, so it gives me some idea of what I need to be worried about in this case. And by the way, my expert reports are going to be due on March 24th. So I've got 15 days to respond to this with my experts. And what I've got to worry about, what I have been given notice of, what Mr. Kemp has told me, this is what I got to worry about, is these two things. Is not going to give accurate readings when used for negative ORP measurements, and two, that the reason that they don't give accurate readings is because I never told anyone that in the product literature that he's claiming these instructions, that unless I rigorously clean it every 30 days. But what we didn't hear today is anything about rigorously cleaning something for 30 days, or every 30 days. Mr. Kemp never talked about that. But that's his complaint. So I hire a chemist to tell me about what am I dealing with this cleaning? What am I dealing with this negative ORP? Mr. Kemp didn't hire a chemist or anyone that's qualified to give these opinions. They're subject matters of other motions that we have before you, but if this is what he says, I don't have to tell you what to do in my complaint, but when you do tell me, when you do give me notice of what you're suing me for, I got to take you at your word. This is what you said, as we've heard many times by Mr. Kemp while he's been up here, that's their words. Well, literally, this is their complaint. And this is what they say I have to be worried about. Rigorously cleaning this ORP meter every 30 days. John, just so we're good, can you open up again just a little bit and not we get to 169, because I don't want the judge to believe that there's something else here. As a direct approximate cause of the elevated levels of toxins in defendant's bottled water product, which is not mine, okay? Are we good with that? Real Water and my company, Hanna Instruments, are not the same company. I don't think we're going to get a challenge on that. Plaintiffs have suffered substantial adverse health consequences, including severe liver damage. Now, I don't believe that Mr. Kemp is going to say, no, the Hanna Instruments was selling bottled water products. We're not in that business. We don't. So the only thing I know is, doesn't give me accurate readings, and the reason is because you've got to vigorously clean it every 30 days. And then he gets up and tells you about something else. Oxidation, conditioning, okay? He tries to get away from the word calibration because the instruction manual flat out tells you, and we'll get into this later in some other motions, calibration is done at the factory. So the user doesn't calibrate the meter, ever. And then it's not the meter that gets conditioned, it's the probe, which he showed you that in the courtroom. So the notice that, and as Mr. Robbins said, how am I supposed to defend something I'm not given notice of, it's not pled, and then when they do give me words, these are the words that I deal with. In 168. Right? Rigorous cleaning every day, every 30 days. That doesn't make sense. I'll go over some of the facts as to why this motion should not be granted. Defendants Hanna and Milwaukee made and marketed. First problem, Hanna and Milwaukee's don't make the ORP meter. Okay? Number two, Hanna doesn't market Milwaukee meters. Next page, I'm looking at their motion. I'm looking at page 3. They put up a series of things saying, oh, this is yours, meaning Hanna's documents. No, they're not. We showed you in our examples that all of them are from people, companies. One of these is called watertesters.com. I don't know who they are. It's in our exhibits. Exhibit 3. I don't know who that is. They're not part of the company. They're people that want to sell this at some other point. It's not us. It's certainly not Hanna Instruments. We just sell it as a wholesaler to Milwaukee. Page 6 of their motion. I have tons of Kangen water customers. I think Mr. Robbins went over that quite a bit. Kangen is actually a Japanese word. It was made by a Japanese company to make this stuff. Here's the big difference that maybe, and I don't believe the other side understands this. Kangen does not use chemicals. Real water uses chemicals to make alkaline water. Kangen does not. Kangen, they put, as Mr. Robbins describes, puts a machine on your kitchen table or counter next to your sink. You run your tap water from your faucet on your sink into this machine. It then goes through a series of electrodes, and it makes it, and it changes it from positive and negative, and that's it. Positive charged water, negative charged water. Then they isolate the negative, and then they do it negative again and negative again. They do this several times in that machine. And then they separate that to where all you're getting is the negative water. You then have a Dixie cup or glass, whatever you want, over here on the side. The water flows into that cup, and you drink it. But they don't add any chemicals. So I'm drinking water from the tap. When I'm buying real water product, as Blaine Jones shows on his video, he literally puts chemicals in. And now they want us to believe we know real water is using chemicals to make their water. Not only that, somehow they're going to say, oh, and you should have known hydrazine was here. We don't know anything about that. We don't know there's hydrazine. We don't know there's chemicals. We just know that they want negatively charged water. In our opposition, we told the court exactly what is a page 11 of our opposition. This is the statement of Dr. Babcock. ORP, in oxygen reduction potential, oxidation reduction potential. Page 11, line 12 or 11. So sorry, number 1. ORP is a measure of the ability of a solution to donate or accept electrons. That's literally the science. It just measures. So what we were first concerned with is that we were going to get, and it's going to be a subject matter of another motion, this idea that somehow this meter here was adding chemicals to water. All it measures is whether or not a solution can accept or donate electrons. Now, let me make sure you understand that. In this particular way, does it say anything about safe drinking water or safety device or safety instrument or food and beverage or no? You can put this same probe in a can of gasoline if you want to, and you will get a measurement. But don't drink gasoline. What it does say right on the warning of the box that Mr. Kemp showed you earlier, didn't tell you this, is that it says right here, the enclosed product is intended to be used by persons knowledgeable in safe laboratory practices. What we'll probably have is a lot of evidence in this case that real water did not use safe laboratory practices in the way that they made their water. So they violated the very warning that's on the box that comes with this product. Last thing I want to talk about, Mr. Robbins made reference, is there's a photograph right here, Your Honor. I don't know if you can see it there or not.
Yeah, you can see it.
ORP new probe conditioning instructions. There's the instructions on how to use this. We just go right back out. So there's the instructions. Here's what you need to do in order to do that. It takes about 5 minutes. those are the solutions that you made. They're manufactured by Milwaukee. This is the MA9025 oxidation kit. On March 23rd of this year, I, a paralegal, went to Real Water's facility in Henderson. And this is what we found. So in order to oxidize the probe of a new Milwaukee instrument, this is what we found. Whether or not Real Water used this to oxidize their probes, I don't know, but they have it. They can do it. So this time of 5 hours, 5 months, 5 days, they have the kit you need to oxidize so that, not that it's accurate, so that it does it more quickly. Oxidation of the probe has nothing to do with accuracy of the meter. Remember, there's two different parts here. We have a meter, that's the LCD screen that you see on the meter. That's certainly not dipped in these chemicals that you see on the screen right now. The probe, that platinum tip is, okay? And Real Water has the kit. They have it when I found it in March of 2023. And by the way, these chemicals right here, reusable. You could reuse this thing for quite a while, certainly during the time period that we're dealing with in this particular case. So they've got the kit to oxidize, takes 5 minutes, here it is. Then we have this statement by Casey Aikens. Last thing I want to go over. Casey Aikens says, I talked to Blaine Jones because I got a reading, and I'm going to forgive Mr. Kemp on the numbers that he used because they were all over the board. There's no sense in making a mountain out of that, so we get to try. Real Water set out a parameter. We want our water to be negative 225 to negative 300. Okay? Mr. Aikens says in his deposition, you have a copy of it, if you don't, we'll get one for you, that on a particular date, in and around September 30th, 2020, he put the probe in a jug of a 5 gallon container of the Real Water. His testimony is it read negative 130. That was below the parameter that Real Water established. Understand, we don't tell you what to do with it once you get it. If you want negative 50, fine. If you want negative 700, fine. If you want a positive 300, fine. You can do all of those numbers that you want. But Mr. Aikens says it was negative 130. So here's the problem that we have as far as this, we're going to go back to causation eventually, but in this motion, the fit for what? Fit for this reading? Yes, it'll get there. Okay? Depending on the chemicals that you put in it, we don't tell you what chemicals to put into it. We don't tell you how many times to run it through the electrodes to get it negative and negative and more negative and more negative. We don't tell you that. All we can do is measure a solution and tell you what it is. So they run it through there, it comes up negative 130. Blaine Jones, phone call. Hey, Mr. Jones, it's negative 130. What should I do? Not, hey, let me call Jason Brown back at Milwaukee. I got negative 130. What should I do? No, we're not telling Jason Brown the specific fit for this. We're not telling him at all. We want it to be here. That's the fit that they're going to try to get us into here. And a motion for summary judgment for that. Okay? We can't fit that. They didn't plead it, number one, and we can't fit that into this. Because we don't know what their fit is. But we certainly don't want a motion for summary judgment granted to say this is what the fit that we knew was going to happen. Nope. Nope. We don't. They asked Mr. Jones. They asked Jones, Jones's reply is, add more chemicals. What does that infer? Well, if it means add more chemicals, it also means don't change out the probe. In other words, Mr. Jones, by saying add more chemicals, believes the MW500's reading on that day was accurate. Because if it was, in his mind, a belief that it was inaccurate, he would have said change out the probe. So he then says to Mr. Aiken, add more chemicals. Now, Mr. Aiken then decides on his own, what I'll do is I'll take what was 5 gallons of this concentrate and I'll just double that into the tank. He puts in 2. That's in his deposition. Mr. Neale questioned him on those questions when we took his deposition, I want to say in beginning of May of 2023. You have that testimony. He decided, not a fit for us, Hanna, the distributor, or Milwaukee, the seller, to someone else. So when they talk about something went wrong here, where did it go wrong? It went wrong when Case Aiken says, I'm going to double this. I'm going to double what this is. And then they did so. And we have no testimony that anything else was done with the ORP meter at that time. Thank you for your time today, Your Honor. This motion for summary judgment should be denied.
Your Honor, first of all, let's start out with what notice pleading means, because I think there's a difference of opinion between defendants and the Western Court. Mr. Rasmussen showed you paragraph 168. Can we see the other paragraphs? Was there one over here? The complaint paragraphs? So this is, again, this is specifically as to Hanna in Milwaukee. The fact about an originally designed, no warnings, or meters cannot read a negative warp state unless the proper platinum probe is properly oxidized. I mean, how much more clear can you have the liability period? There's no, is there, where's 2, Shane? That it must be cleaned every 3 days, that it has to be calibrated, that the meter has to be replaced. They didn't give any warning like this. But the primary one in this case is they didn't tell people in the user manual that it wasn't done. Okay, that is the notice that we gave them. And that is sufficient under our law to support any type of strict liability claim. And, you know, they didn't discuss the holdings of these cases, okay? The Western States case, again, that's the primary case. Notice pleading, liberally construed pleadings to place into issue matters which are fairly noticed to adverse party. How can they say they weren't noticed when it's right there in front of them? And then this is the listing case, the very first one I started with. This is the Supreme Court holding. This standard, quote, requires plaintiff to set forth the facts which support the legal theory, but does not require the legal theory relied upon to be correctly identified. It didn't matter what I put up there. I wasn't required to put anything up there, much less put every type of legal theory that we're going to assert. That's the listing case. The next case, the Schwartz case. A plaintiff who fails to use the precise legalese describing his grievance, but who sets forth the facts which support the complaint, thus satisfies the requisites of notice pleading. Then Judge Beulah's case, the Drove case. For purposes of Nevada's notice pleading standards, such allegations provide sufficient notice. And in that case, there was they changed the trespass to a breach of peace or something like that. But in any event, Your Honor, the analysis is not what the title of the cause of action says. It's whether the facts are sufficient to support the claim. And I just don't understand their argument here in the notice pleading state that the facts that we pled are not sufficient to support a breach of implied warranty And like I've already said, that's the flip side of unreasonably dangerous. That's their first argument, the procedural argument. Argument number two, we heard, was Kangen water is not real water. Well, that's true. Real water is a pretty unique product, Your Honor. But Kangen water is alkaline water. And that's what the particular purpose summary judgment motion is directed to. That they knew that the product was being used to take negative ORC readings for alkaline water. I didn't say anything whatsoever about adding chemicals, that they knew chemicals were being added. I said that they knew, and they did know, because I showed you Mr. Brown's testimony on the request for admissions. They knew that it was being used to take negative ORC readings on alkaline water because 1/3 of their customers were using it to make alkaline water, including the Kangen water. 1/3 of their customers. They called him, I showed you his testimony, he had tons, not one, not two, not here and there, every other year. He had tons of alkaline water customers. So they knew that they were selling the meter to these alkaline water customers that were using it to take negative readings. That's it. That's what the summary judgment talks about, okay? And then Mr. Rasmussen says, and I couldn't believe he said that. He said, quote, "We just knew they want negatively charged water." Unquote. He's talking about the customers. Quote, "We just knew they want negatively charged water." Unquote. Well, that's the whole motion, that the particular purpose was that they're using it to measure negative ORC when they're making alkaline water. That is the whole motion right there. I haven't asked for causation. I haven't asked that it was unfit. Okay, we heard a lot of argument about both of those subjects. All I asked for was that one of the particular purposes was what he just admitted, that they knew that they wanted to use the meter to measure negative charges in water. That's it. That's the simple motion, Your Honor. And now we get to the testimony that Mr. Brown was sick. You know, I feel like I flogged this guy when I was asking questions, listening to the way this deposition is portrayed. First of all, Mr. Jones came back to work. He was working for a couple days before we did the deposition. Second of all, in the deposition, he testifies that his doctor gave him a medical release, so he had a medical release. Third of all, we delayed this deposition months waiting for him to get back. You know, counsel makes it sound like I got Special Master Hale to order to be taken from the hospital bed. That is not what happened here. And fourth, and I think this is the key point, he goes on and on about how his own witnesses, the general manager, his testimony is poppycock, was his word. Nonsensical was his word. Well, do you know what they did with all that testimony for the next 30 days while they were entitled to change it if it was wrong? They were entitled to file an erratum if it was wrong. They did nothing. There was no erratum filed. So now they come to court and they see the significance of the testimony, that he knew that the meter was being used for these purposes, that he knew it would take hours and days to work. Now they're trying to run from that testimony, and given that he's such a key employee, the general manager, the only thing they can come up with was he was sick, Your Honor. But you know, maybe that's for another day. But the bottom line here is they knew what this meter was being purchased for by 1/3 of the customers, and that was to take negative ORC readings when making alkaline water. And that is the only thing that we have asked for summary judgment on. The other point, the causation, you know, we heard an argument from Mr. Rasmussen on causation that, you know, Mr. Jones should have known the meter was wrong, or some called up Mr. Brown from the factory floor. I don't know what his argument was exactly, but I'm not asking for summary judgment causation. He can tell the jury that it didn't make any difference. That's fine with me. He can tell the jury that this is fit, that a meter that takes hours or days to take negative readings is not properly conditioned. He can argue its fitness. I'm not asking for a summary judgment motion. I'm just asking for a summary judgment motion on the point the counsel admitted during the argument. And his quote again was, "We just knew they want negatively charged water And my motion is that one of the particular purposes was to measure negative oil when making alkaline water. I mean, it's pretty simple.
I just have, just kind of a follow-up as it pertains to the holdings. And I do understand you relied upon, I guess, 3 cases, but you also have Judson's versus Cavanaugh Foods, right? And that case specifically deals with Ray-ups and Oakwood. And apparently the plaintiff, it was a premise liability case of a pizzeria. And they never pled Ray-ups and Oakwood, they only pled general negligence.
Correct.
And it's my understanding, I think it was Justice Gibbons, might have been his case, but he said, and I'm just paraphrasing here, he focused on the allegation that general negligence would be sufficient because Ray-ups and Oakwood is a form of negligence.
Right, yeah, Your Honor, we looked at that case, but the quote, the holding wasn't tight enough for us.
Okay.
Yeah, that's the reason we decided that. But it's the same principle from Liston, Schwartz, and recent Court of Appeals case.
What's your response to that? I just want to make sure I'm clear before I.
With regard to the 3 additional cases they cited in the reply. You just give me 1 minute.
But I just thought about that in general, because I noticed that was
So-
cited.
I mean, generally, with regard to all 3 of those cases, if you read them, it's been a minute since I read them, but there was additional evidence, okay? In this particular case, we have, when they filed all those amended pleas, initially when this complaint was filed, we were lumped in with everything, and we called their office and said, hey, you know, it looks like the bulk of these are against real water, and then you just, maybe something else against us. So then when they amended it the first time, that was cleaned up, so we didn't have to file motions for definite statement or anything. And then we get the second amended motion, okay, and then we get it at the same time that we have it in all the other cases, okay? And in that, they intentionally filed an 8th cause of action for breach of implied warranty. They intentionally did not do it in this case, okay? So I'm not just getting additional information that the courts in these 3 cases cite to and generally refer to, and that's why they made the exception, that there was additional information. We got counter information that you're not going to be facing this cause of action in this particular case. So that's number 1. The other one, there's another case, and again, I didn't get to respond to this, and I can get Your Honor the site. It's a 2015 case which came after a couple of these cases. I think it's called Nutton, N-U-T-T-O-N.
I'm familiar with that.
Okay, and I generally believe that that
Rule
states.
16 case, but go ahead.
Okay, in 2016?
No, it's primarily deals with.
Oh, Rule 16.
Rule 16, good cause standard.
Yeah. And it basically, when it was used against me, it was something to the effect that if you miss a deadline, you know, you still, under 15A, you could even, there are cases where you can amend your pleading
I can tell
after
you what
trial.
it says. Well, it's
But
slightly
you-
different, but there was a tension between Rule 15A and Rule 16.
Correct.
Right, and at the end of the day, the Nevada Supreme Court said, when it comes to an amendment of the court's scheduling order, the good cause standard applies.
Exactly.
Something like
So basically, before you get to the freely given part, there's gotta be a good cause if you miss that date. And, you know, they could have certainly come to court and did that, they filed this motion. But what they did is they intentionally told me, when they amended the other cases, you're not gonna be facing this case, this is your issue, you don't have to have an expert look at this, you don't have to depose on this issue. And it's a different issue than strict liability. You know, you don't have reliance, you don't have any of the, potentially the privity arguments, okay? These people, keep in mind, his clients have never touched an ORC meter. They didn't fall on the ORC meter, you know, putting aside whether they bought an ORC meter. They didn't come and fall on the ORC meter and get hurt. They've never even contacted the ORC meter, and the product they did drink, my ORC meter never touched that product. So what I'm more upset about is if you wanted to have this cause of action, you filed on between February 21st and 23rd, and all those other cases that I list on page 8 of the opposition, at line 8. You have all the other cases. You did that in all the other cases. You intentionally didn't do it in this case. So if you're asking me about those 3 additional cases that they're citing in their reply, the difference is you're talking about getting more information in those cases. That's what they relied on. And then you've got the Nutton issue that there was good cause. I'm saying they went the other way. they said, that's a message to me, that's directly telling me you're not gonna face that cause of action. And I suspect it's because of the trial date, maybe there's, they're bright guys, so maybe it's a different reason. But that's what my office believed, that's what was communicated to my client. And so therefore, I think that's what distinguishes it from those three cases. We're getting the opposite, we're getting the information that this is not gonna happen. So I don't think that's fair, I think it's prejudicial to us. Had they wanted to do this, I know Your Honor would have considered it, probably would have granted it, and could have fashioned something. They chose, this is an intentional choosing of not to bring that cause of action and give me proper notice of it. And then come to court on the eve of trial and try to backdoor the client. That's my problem with it. I mean, what he's asking for is a very limited thing. In fact, I think he just proved his own case, that it does take negative readings anyways, with this video. But regardless of that, that's not the point of this motion. The point of this motion, no matter how much they want to try to limit that cause of action and use it later on, you had an opportunity to plead it, you didn't. You knew you should have pled it, you knew it wasn't an included cause of action, because you had to go add an 8th cause of action to all those other cases. So I'm getting information that's telling me we're not gonna deal with that cause of action, not in this case. And they shouldn't be allowed to now come and backdoor, not only getting the claim in, but a summary judgment motion. And that's the procedure, substantively, there are issues of fact. So that would also prevent you from resting easy with granting this type of motion. So that's my problem with it, Your Honor, and that's my problem with those three cases. We got the opposite, okay? We're getting less information. We're being told it's not gonna be part of the case, and now here it is. That's my problem.
First on the amendment, the primary purpose of that amendment was to drop the deceptive claim, trade practice claim against Real Water, because one of their insurance companies had indicated that was grounds for coverage now. So that motion to amend dropped that particular claim, not just in this case, but in all the cases. Counsel is correct that we did a better job in the other cases, I will admit that, in setting forth the claim, but that's not the test. The test is, and he had it in the other cases. Why didn't he just, he knew the facts supported it because it was applied in the other cases. But, he says that you can distinguish Liston and Judge Boole's case, which is the drug case, and Swartz because there was additional evidence. That's not true, at least as to the Swartz case, because that issue was decided on appeal. The case went up on appeal, and they allowed the plaintiffs to switch over from the conversion to the due process on appeal. And in no case it said there has to be additional evidence. It just says notice pleading. You have to give them notice. And Mr. Rasmussen admitted the fact. Mr. Robbins says this is a very limited summary judgment motion. Not asking for declaration of fitness, not asking for causation. All I'm asking is the court find exactly what Mr. Rasmussen just admitted, that they knew that the meter was being used to take negative or readings when people were making out money. That's all we're asking. And I could go on, Your Honor, but I think it's a pretty simple matter.
Okay, gentlemen, this is what I'm going to do. I just want to make sure I get this correct. Okay, what I'm gonna do, as far as the motion's concerned, it's gonna be limited. to the request is specifically set forth on page 11 of the conclusion. And that would be NW 500 was being used to take negative warp readings when making alkaline water, period. Nothing more, nothing less.
And that's expressly as you stated.
Yes. I did that on purpose.
Yeah, good.
Thank you.
As you know. So, break, or what do we go from? What time is it? The break. They need a break. To be a nuisance.
All right.
Thank you, ladies and gentlemen. That'll be a 10, 15-minute break. Please remind that may be a judicial time.
All right.
Purpose is used now, such times with one. Please be seated.
And I guess next up would be the Gallagher versus Affinity lifestyle matter. Let's go ahead and set forth our appearances for the record.
Morning, Your Honor. Eric Pepperman for plaintiff.
Good morning, Your Honor. Teddy Parker on behalf of Plaintiffs. Good morning, Your Honor. Jim Neale on behalf of UNFI.
Good morning, Your Honor. Joe Rasmussen on behalf of UNFI.
Good morning, Your Honor. Joel Odou on behalf of Bluewater Inc. and AffinityLifestyles.com Inc. Mr. Kaufman is ill and is planning to remote in tomorrow, but not today, so hopefully we'll have blue jeans tomorrow.
Okay.
Good morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments with Breathing Lions.
Bob Robbins for Milwaukee Instruments, Your Honor.
Good morning, Your Honor. David Spurlock, UNFI.
Good morning, Your Honor. Jim Cavanaugh, for Grillwater, Tennessee, LLC.
All right, good morning once again. And before we get started, I just want to make sure we're fine. There's an issue regarding the record, ma'am. Can you explain to me what we need to do?
Yes, so in Odyssey, when a lot of the joinders were filed, they were filed as just joinder, that's what they were labeled as, instead of joinder to opposition, some of them are joinders to opposition. Judge rules on motions, so in order for me to result any of the joinders, they have to match with the motion. And some of these joinders that are joinders to oppositions are showing up on our calendar. Can't result them because he doesn't rule on opposition. So I need to, if it's okay with everyone, relabel them as joinder to opposition if that's what it is. And then also, each document has a docket number. So when one motion is being argued and then somebody else says, we joined, I need to know the docket number because there's so many motions that we're hearing right now. I need to know what matches with what, if you guys can help me with that.
So, with regard to Hanna, who's probably joined several of the opposition, I'm absolutely fine with you relabeling all of our jointers with our two oppositions as that.
Thank you.
Okay.
Same on behalf of Bluewater. I'm just not seeing the docket number on the document, so we printed out in hard copy. So otherwise I would say, docket whatever.
I understand, well, you don't have access to that.
I don't.
I'm doing my best to go through everything and label them so that when it shows up on the calendar, it will have the document number in front of the motion title, but there's a lot, so bear with me.
All right, anything else? I mean, for example, everyone doesn't have a copy of this, do they?
Right, but it does show you, obviously.
So they'd have to be on Odyssey to give you that number.
I believe it should be on the attorney side of Odyssey, when you look at your calendar. In the comments, it'll show.
Yeah, I'll be able to print that out tomorrow. I just didn't bring it.
Does it show it, sir?
Your Honor, it stops showing a docket number right when we get to all the motion, pre-trial motions.
Yeah, and that's
So-
what I'm having to go through and
So the dockets
enter them in.
aren't listed in this.
So council wouldn't know the document. Right?
Yeah, we don't know it on this.
So I guess, for the record, all we can do is just to make sure it's clear, that when you join in, just restate the motion you're joining in, and she can go ahead and change that join into whatever motion might be, or opposition.
Okay.
Does that make sense, everyone?
Yes, Your Honor.
Yes. Okay, all right.
Judge, if they want to file something, we don't have any objection to filing some omnibus joinder to clear the record if they need to do that.
And maybe
Yeah, it's just the court.
whatever, I mean, I don't know if we need one now, but if down the road we need to do it, we can do it. Okay. So ultimately, where do we end up?
I think we're on 3, Your Honor.
We are on number 3. My understanding was Mr. Neale was going to withdraw his opposition to number 3.
That's correct, Your Honor. In light of the court's ruling on plaintiff's motion to eliminate number 2, UNFW withdraws its opposition to plaintiff's motion to eliminate number 3, and the court can grant that as uncontested.
All right. And that's what we'll do.
That would bring us to plaintiff's motion to eliminate number 4, which is to pre-admit the Loma Linda article.
Okay, you have a floor, sir.
Thank you, Your Honor. I'm going to pull up on the screen the article that we're talking about in this motion. Shane, if you could pull it up. So, Your Honor, by motion to eliminate number 4, we seek to pre-admit a published, peer-reviewed journal article titled "Acute Liver Failure Due to Manufactured Alkaline Water, a Case Series of Real Water-Induced Liver Injury." This is an article that looked at 4 different patients who suffered acute liver failure injuries associated with consuming real water. The authors are Corey Burke, Tarek Amar, and Brian Lee. We took the deposition of Dr. Amar, who authenticated the article. He confirmed that this article was it's peer-reviewed and published in the American Journal of Gastroenterology, and confirmed that that journal is the leading gastroenterology medical journal in the United States. This article was relied upon in the Morbidity and Mortality Weekly Report article that was pre-admitted yesterday without objection. Shane, if you could please pull up the MMWR article. And if you go down to the second page, I believe. Footnote 2. See the Southern Nevada Health District Morbidity and Mortality Weekly Report is citing the Burke et al. Article that we seek to pre-admit here. So what we have is an article that was relied upon by the MMWR article, which was pre-admitted. This article was relied upon by multiple plaintiff experts. It's been relied upon by multiple defense experts, including Dr. Goldsmith, as set forth in the brief. It's a peer-reviewed article contained in a published treatise. Dr. Amar, one of the authors of the article, established that it was a article published in a learned treatise, the American Journal of Gastroenterology, and all this has been established by the testimony of multiple experts, including Dr. Amar, who's one of the authors. This article, the case series of 4 acute liver failure cases associated with real water, it's also evidence of prior and subsequent injuries associated with real water. It's admissible separate and apart from the learned treatise hearsay exception, which is 51.255. It's also separately admissible and relevant as
evidence of prior or subsequent injuries under Guinness, Robinson, ADV Thomas, and the numerous other precedents allowing for evidence of prior and subsequent similar incidents involving same or similar product. If we look at one of the patients in this article is Daisy Way, as an example. And in the article, if we can pull up the journal article. If you can go to the chart on the second page, I believe. And patient number 1 shows the dates of the injuries that were treated. And patient number 1 is Daisy Way, but beside the identity, it shows that this patient was hospitalized. The date of presentation was June 2020 and October 2020. So this is a person hospitalized in June 2020 with suspected acute liver failure associated with real water. And Your Honor, this I think is the real reason they're, mounting an opposition to this, which I think is a pretty straightforward motion to pre-admit a peer-reviewed published journal article that's relied on by the experts, relied on by the Southern Nevada Health District, and clearly documents multiple similar incidents to the plaintiffs at issue in this case. It's not irrelevant as suggested in the opposition. It just goes against this Henderson-only theory, because obviously this potential case in June 2020 cannot have been related to the Henderson facility, which wasn't, no question that it was not in existence until August of 2020. Our last point on this is that I think something that you said yesterday on the hearsay stuck with me as important on this motion. What's the concern with hearsay? It's something's untrustworthy. It's a statement that's out of court that's untrustworthy.
Well, and the reason why I say that's the basis for all hearsay exceptions.
Exactly, Your Honor. And so if there's a concern with trustworthiness.
And that's from a policy perspective as it relates to the exceptions.
Exactly. And it's a point that bears emphasis here, because that's the issue with this article is it admissible under a hearsay exception? And the hearsay exception is the learned treatise exception. It's clearly a published literature contained in a scientific journal. It's peer-reviewed. There's nothing untrustworthy about this. It's clearly relevant, and all we're asking is that it be pre-admitted. Thank you.
Good morning, Your Honor.
Good morning.
Before I start on the hearsay issue, I should note, and this will probably come up with a number of these motions, that this article is actually the subject of a motion in limine filed by Real Water that's not scheduled to be heard for some time. So Mr. Odou may have arguments about the admissibility at trial. I'm sure the court will get to those. But this motion is about pre-admission of an out-of-court statement offered for the truth, not whether there are circumstances at trial where a party will be able to show foundation relevance in an exception to the hearsay rule. Now, the case report describes 4 patients, none of whom are plaintiffs in this case. And so there are concerns about relevance. We don't know circumstances of the plaintiffs, but those arguments, I'm sure the court will get to, but plaintiff's claim, I'll focus on the hearsay exception claim. And they claim that the learned treatise exception allows for the pre-admission of this article, but the language of that exception, and I'll ask Mr. Stevens to put it up, makes clear that.
And what's the statute now?
It is NRS 51.255.
Okay, continue on.
And the language makes clear that pre-admission is unavailable for a paper like this. You'll see it reads, to the extent called to the attention of an expert witness upon cross-examination or relied upon by the expert witness in direct examination, then a statement in a published treatise, etc., is not inadmissible under the hearsay rule if such book is established as a reliable authority by the testimony or admission of the witness or by other expert testimony or by judicial notice. So, Your Honor, this exception applies when a witness testifies at trial as to the article. And so I don't think that can be accomplished before trial. And that's the basis of our opposition. I know that at least one other party filed an opposition to this motion, and I know that there's still outstanding Mr. Odou's motion as well for the exclusion of this article to show causation. So I will let those parties address it.
Thank you, ma'am.
Thanks.
Joel, on behalf of Real Water, just very briefly, Your Honor, we filed a slightly different motion. Judicial value always probative nature because these are not plaintiffs in this case and it shouldn't be admitted into evidence. If it makes sense to defer ruling on this one until we get to that one, that's fine. That kind of summarizes some of the arguments on this. So if we want to handle both at the same time, I guess we could do that too.
Mr. Pepperman. I mean, I don't mind telling you this. I mean, I understand the position taken by the defense. They're saying, look, Judge, in a general sense, the objection is based upon the simple fact that pre-admitting without some expert's introduction and evidence relying upon a foundation and all those types of things. That's what you're saying, right, ma'am?
Yes, Your Honor. You put it better than I did.
That's the extent of her objection. And in essence, all she's saying is, look, somebody has to, whether it's one of the treating physicians, when they testify as to potential injury, causation, and those things, because, many times under Hallmark, in order to meet the assistance requirement, experts can rely upon learned treatises and many times peer-reviewed articles. And so, for example, the doctor in this case might be given an opinion as to injury causation in this case. And the question is whether they can rely upon this learned treatise. But the doctor has to, of course, rely upon that. And that's kind of what they're saying. They're saying, we'll get to, I don't want to talk for Mr. Odou because he hasn't really dug in, but that appears to me to be the extent of the opposition. So.
Yes, Your Honor, that's correct. And I would just make 2 points to that. Number one is NRS 51.255 doesn't say anything about trial. It says to the extent called upon.
But don't we, I mean, I kind of get it, but at the end of the day, don't you have a doc to tie it up?
Well, we do.
Okay then, I mean, that's all I'm saying. You have to have a doc to tie it up. And so I'm not saying it can't necessarily come in, but it seems to me, for example, what if you had a situation where there was no doc and you file this motion to have pre-admitted peer-reviewed articles? Is counsel going to argue this is what the article says? Don't you have to have someone else, an expert?
Well, we did. Yes, Your Honor.
I'm not saying you, but so you understand what the issue is.
Yes, I mean, mechanically, if it's pre-admitted, it will be used in the testimony of one of the authors who we deposed that witness, as well as multiple experts.
Right.
Mechanically, that's how it'll work. But in terms of the pre-admission, it was called to the attention of multiple doctors who testified about it. And so it qualifies under NRS 51.255, which doesn't say this has to be done at trial or preclude pre-admission. So that's just one point. The second point is, although that's one of the reasons to use, the experts relied on it for giving their testimony, and it was used to confront defense experts as well, and it'll be used in all those ways. It's also separate and apart from that, evidence of prior and subsequent similar real water liver injuries. So that, in and of itself, is a separate reason that the article is relevant, even if none of the experts were to rely on it. It's still evidence of these other injuries that, Your Honor is aware by now that, that's gonna be a contested issue, as we heard Mr. Neale stand up and say, tens of millions of bottles a year sold, and there's no other injuries related to it, and it's all Henderson. We disagree with that characterization of things. I only wish that tens of millions of real water bottles have been sold, and we may not be here today, but in any event, that is an issue. This is evidence, clear evidence in a published journal of multiple cases of similar prior and subsequent real water injuries. So for that basis alone, it is admissible. And Your Honor, I get what you're saying as well in terms of the objection is it pre-admissible or not? I don't think there's any question.
I think if it's pre-admissible, it should be, it's like right here, this is what you say on page 3, line 10 of your motion. You say, quote, in their expert reports, several of plaintiff's experts rely upon the Loma Linda article, period. And so that's kind of what you're saying is, look, Judge, we want to pre-admit it. But along with that, the experts are relying upon the report.
Absolutely, Your Honor. And even on top of that, it's relied upon in the MMWR article, which has already been pre-admitted without objection. So for all those reasons, it's a simple pre-admission of evidence that's clearly admissible, clearly important, and whether we have arguments over what's the weight of it, what's the significance of it, that doesn't really affect the admissibility issues that we're seeking a pre-trial ruling on here.
And Your Honor, I think you understand our argument. Our position is the article should not be shown to the jury until there's an expert on the stand who's been qualified and laid a foundation for it. That's what the statute says. If it is evidence of prior or subsequent events, that goes to relevance. That doesn't go to whether there's an exception to the hearsay rule. And we do not believe that the exception can be satisfied until there is an individual on the stand who can rely on the article.
Your Honor, we don't need an expert to admit evidence of prior or subsequent similar injuries, number one. Number two, the whole point of the it doesn't affect whether, their concern in the opposition paper seems to be, if it's not pre-admitted, we can't use it or reference it in the opening. That's not what the rule is. What we're looking to do is avoid this very argument at the time when we introduce it through the relevant witnesses at trial, to spend the time making an argument in front of the jury about the admissibility of a simple peer-reviewed journal article that is clearly relevant. So that's the motivation behind the motion to pre-admit. From our perspective, and of course the court can inform me if I'm misunderstanding something, but the fact that evidence hasn't been admitted yet doesn't preclude us from using it or referencing it in opening statements if we have a good faith belief that it will be introduced and admissible in the trial. And if it ends up not being, then that's the risk that we take. But I think with something like this, there's really no question that it's admissible, that the argument really isn't that it's inadmissible. It's just, they should wait until we have an expert on the stand so they can raise this objection up in the middle of trial, and we can dedicate a bunch of needless time when we can easily get a pre-admission ruling here and avoid it when the time comes.
Mr. Odou, what did you want to add?
Yes, Your Honor, just we'd like our motion heard. We're kind of getting to the point where the issue is strayed from pre-admission to, if it's pre-admitted, obviously it's admitted, and we had a different motion on this. And we think it probably makes sense to hold the ruling in advance and do it all at once, and if that's the way we're going to do it.
Mr. Pepperman.
Was there an opposition from Real Water?
Well, I think what it is, what he's saying, I don't think there was an opposition, but they have a motion in limine. Which one is that?
For,
Defense motion in limine number 2. There's a lot here. Is it number
4, Your Honor.
number defendant? No, that should.
Judge, actually, I think that this issue is raised in 10A and B filed by UNFI.
Okay.
We did a joint opposition to those and also to his because there's probably, I don't know, 6, 7 motions that deal with this. This concept of theirs that you can't admit prior instance unless you have medical expert testimony. And so the first one I think is coming up is their motion 10A and 10B, UNFI's motion. And that's, in our opposition, like I already said, we addressed the arguments made by Real Water too. We filed a joint op to that.
And it's 10A, is that your motion?
No, that's,
That's ours, but that actually, we don't have a motion related to the admissibility of this article, that's a different issue. The motion was Real Water's motion in limine number 4, which originally had been set, I believe, on the July 27th calendar.
Your Honor, 10A is a motion to exclude Christopher Wren, anything to do with Christopher Wren, because according to the UNFI, we have to prove medical causation. 10B is their motion to exclude evidence of Jerry Watkins. Jerry Watkins is a plaintiff who in 2018, his wife wrote an email to Real Water that said, my husband's in the hospital, the doctor says his liver injury is caused by alcohol and water. Okay, so this is their motion to preclude that. And then there's a number of other incidences. Mrs. Kessler, who was a woman in California who got a liver injury. They filed a motion to preclude that. There's a guy in Florida, Mr. Dorn, I think it is. He drank Fisher. And then there's another woman named Dorn. So there's all these prior incidences, and we filed a joint opposition to all of them because they all raise the same issues. They all argue that if it's a prior incident, you can't admit it unless you have medical causation testimony, which we contend is wrong. But I mean, I don't mind waiting until we do 10A and B, but that's where this issue is going to get thrust out and ruled upon.
And you have number 4.
4.
I was looking here, and you have it wrong. Let's see here. Color coded, which is number 4?
It's yellow, it's number 311.
Okay.
Your Honor, we could hear Real Water's concerns with this article. And my understanding is from the statements was, well, because these 4 patients are not plaintiffs in this case, then they're somehow irrelevant. Again, I think our position on that is, of course they're relevant because there's other similar injuries. They don't have to be plaintiffs. So we're fine addressing that issue. I think it's been fully addressed. If there's anything else to add, we're happy to add it.
Mr. Odou, sir.
I just think it makes sense to hear these, all together when we have multiple motions on the same subject, and we kind of wandered afield from that. We're talking about 10A and 10B. We started with Real Water's motion in limine 4, but this is, plaintiff's motion in limine pre-admit, and I think we've shown that there's some controversy over that, so it probably makes sense to hear all the motions that affect this issue at the same time. Thank you, Mr. Rasmussen. Did you get a chance to weigh in?
We did file an opposition to this motion as well. Ours is not a NRS 51 argument, although we join with those arguments. We did raise this under NRS 48.035 under unfair prejudice that will occur. What I am sensing, Your Honor, is that what we're going to get is a long opening statement from Mr. Kemp that will try to go through all of these articles, all of these other cases, all of these other plaintiffs, all of these other non-parties, all these other people all in opening statement with backed up, we're gonna tell you what this is, and this is how it is, and I don't even know why we're here type arguments, write out in opening statement that you're going to have to deal with a bunch of evidence that has not even been put into evidence. But if we pre-admit a few of these things now, then I get to go ahead and use those during opening statements. And the unfair prejudice to that is, who is introducing them? Mr. Kemp, the lawyer, or a doctor who was actually the one that testified about this? And I believe, and that's where the unfair prejudice comes into, that this jury that we will have should be hearing from the doctor who actually wrote the article than the person who wants to just use it in their opening and say, this is the way it is, I'm the lawyer, listen to me, I'm the authority, which is not the way evidence should be done, and would be completely unfair and prejudicial to us on the defense. Thank you.
Okay, and see, here's the issue, and what I don't have is this, and I think it's a really important point. Let me go back to, this is what's set forth on page 3 of the moving papers. And it says, quote, in their expert report, several of plaintiff's experts rely upon the Loma Linda article. And I assume were they deposed?
Yes, Your Honor, we've taken expert depositions in this case.
What did they say regarding the Loma Linda article in their depositions?
Only that they reviewed it.
They relied upon it?
Yes, I would believe they did, but that's where we will talk to them about that in depth, about what the reliance was in the article. The other problem, of course, is that, for instance, Ms. Way, who Mr. Pepperman talked about, is a plaintiff in another case. So
But, you know,
we're crossing over.
Here's the thing though, and this is where you're gonna have to convince me, because if you look at 99.99% of all peer-reviewed articles that are medical journals and literatures regarding how do you perform a spinal surgery, or it can be how do you perform some sort of neurosurgery and the like, and maybe what the standard of care is, or maybe what the impact of certain foreign substances might be on bodies. None of those cases involve the plaintiffs. And here's my point, it goes straight to the essence of the assistance requirement under Hallmark, right? Is it peer-reviewed, is it regularly relied upon? And just as important too, what's overlooked is peer-reviewed for what purpose?
Right.
And so if it's peer-reviewed for the treatment and care of patients, why would it come in? And here's my point, it doesn't matter whether it's spine, JAMA, or whatever, if it's peer-reviewed and relied upon doctors as the basis for their opinion, why can't it be discussed?
We're not saying it can't be discussed. What was noted in, again, NRS 51 that was there, and then coupled with NRS 48.035 is, when does it come in, and who is the authority that says, this is what I relied on as the doctor, put it up, let the doctor explain it, and do that. That's the person who should be doing this, as stated in the plaintiff's article, in their, which you've cited now twice, in their moving paper, is that their doctors relied on this. Then let's hear from the doctors as to what they saw and use it then. Otherwise, it is unfair to suggest this is already pre-admitted, this is already the gospel of this case, this is where things are at, because that's where the step that they're going to go to in this case, as opposed to, hi, I'm the doctor who treated these people, here's what I got under direct examination as stated in NRS 51. That's when you do this, as opposed to, hi, I'm the lawyer advocating for my clients, I'm going to tell you what the authority is, as opposed to the doctor. And that's the concern that we have on unfair prejudice.
Okay. Why can't you say, hi, I'm Mr. Smith, I represent such and such, and in this case, we've retained Dr. Jones to be the expert in this case, and this is what I anticipate he's going to testify, ladies and gentlemen of the jury. In fact, these are the sources he's relied upon as a support for his testimony.
And that's different, Your Honor, I believe, in saying, this court has already pre-admitted this.
Okay. No, I understand what you're saying, so we're like on the same page in certain respects.
Okay.
I don't think real water raised a specific objection to we in motion limiting number 6, because I'm looking in my opposition, And what they want, in motion limiting number 6, they want lay witnesses not to do medical opinions, which is
The
their,
witness is not doing medical.
that's what they entitled this motion. Okay? They didn't file a motion to preclude reference to way. That no one did. I don't think the way things briefed other than this particular one. But it would cover, I think, the ruling that you're going to get on 10A. In 10A and 10B again, that's motion to eliminate number 10B by UNFI. That's Real Water's motion to eliminate, saying that lay witnesses can't give medical testimony. And what they're seeking to exclude there is evidence that Blaine Jones himself got acute liver injury. So the ruling that comes out of this particular motion is going to impact all of this. Okay, so I don't mind deferring it, but that's where it should be deferred to. I don't know where we're going to get to that, because we filed a joint opposition to it, and we took all the prior incidents in our opposition. We took Mr. Jones, we talk about the 3 people who drank the retail bottles that we've already referred to. We talk about Watkins. We talk about Mr. Pham's testimony that his 2 neighbors drank from Whole Foods and got carted away to the hospital ambulances. We talk about all of that in this particular opposition. So this is the opposition they're trying to preclude all that from the jury. Only if it's precluded, only if you grant this motion eliminate, will we not discuss it. You know, Mr. Rasmussen's suggestion that I can't talk about it during open statement, that's flat out wrong. If I have a good faith belief that the evidence is going to come in, and assuming that this motion eliminate 10, 10B, and the other ones, Real Water 6, 12, and 13, assuming those are not granted, not only do I have a good faith belief, I have a court rule. Okay, so we're going to talk about all these, unless the court rules that we can't talk about them during the opening statement, whether they're pre-admitted or not. So Mr. Rasmussen's fundamental argument is that you can't discuss prior incidents unless they're pre-admitted. That's just not right. So what I wanted to do is wait for the ruling on this one until we get to 10A and 10B. 10B more covers it a little broader. And I'll live by that ruling, but you know, I think Mr. Pepperman is 100% right. This prior incident should come in.
And the only reason I bring this up, because we're kind of going, we're talking about using it for, I mean, in a general sense, when I look at the motion, and this was my thought, here we have a potentially a learned treatise as peer reviewed, and whether that can be pre-admitted. Now we're talking about for other purposes, but in a general sense, assuming it meets the assistance requirement under Hallmark, why wouldn't it, and an expert relies upon it, why wouldn't it come in? It was relevant,
Not
right?
only that, you know, yesterday, they kept arguing we gotta bring an FDA witness who authored. We deposed the author of this. The doctor who authored this has been deposed. His deposition is gonna be played. I don't know what more they want.
Okay. This is kind of how I see it, and I can't just kick the can down the road on every issue. I gotta move on. The reason why I say that is I got a lot on my plate when I look at it. And I want to focus on this issue while it's looking at, and I understand there might be, and I want to make sure the record's real clear. There might be other, I'm not saying, for example, Mr. Odou, you waived your right to raise other issues regarding admissibility. I'm looking at it from this perspective, and it's a real simple motion, and there's other issues out there. But there's a request made pursuant to Rule 51, NRS 51.255, based upon the position taking that this is a learned treatise, right? And asking for pre-admission. Now, I do agree with counsel in this respect. And they actually say that here. In their expert reports, several of the plaintiffs' experts have relied on, right? They say that. And so this doesn't appear to me to be a scenario where we're like in the short trial program, I don't know, if some of you probably have never tried a case in the short trial program. But on the short trial program, you don't have to bring in the experts, you can actually just read their reports to the jury. This isn't that case. So what I want to do is just to make sure, and I want to make sure I'm clear on this. There's no objection based upon the fact that this is not a peer-reviewed report.
Your Honor, we had specific objections to the Burke article in our motion to eliminate. I don't have that with me, and as I alluded to, Mr. Kaufman is ill today, so.
Yeah, but I mean, I'm talking about peer review.
Yeah.
And then secondly, the plaintiff or party to litigation doesn't have to be a participant in the underlying peer-reviewed investigation, right? We can all agree on that.
Yes, Your Honor, but still the prejudicial value may outweigh its probative nature, and that may be a second ground to exclude it, and I think that's what we had discussed.
Okay, but my question is how would, you know what I'm gonna do, and this, I just make sure I'm clear. I'm going to pre-admit it in this context, that in their expert report, several plaintiffs' experts rely upon the Loma Linda article. In fact, he was deposed too, right?
He was, Your Honor.
Okay, and that might be shown to the jury. Now, in making that decision, for example, in subsequent motions in limine, the defense has not waived their right to bring up maybe another issue. I just don't want to have to go back and redo this, or we're never going to. You understand that, Mr. Odou?
Yeah.
There's no waiver, no waiver.
Thank you.
Okay, so let's move on to the next one.